Good afternoon, Your Honors. This is case number IT 0260/1S, the Prosecutor versus Momir Nikolić.
Thank you very much. For the sake of the record, may we have the appearances, please? For the prosecution?
Yes, good afternoon, Mr. President. Peter McCloskey for the Office of the Prosecutor with Stefan Westby and Antoinette Issa and, of course, Janet Stewart.
Thank you. For the accused.
Good afternoon, Your Honors. The accused, Mr. Nikolić, is represented by myself, Veseli Londrovic, and my colleague, Stephen Kirsch. We are assisted by our interpreter, Ms. Vesna Anic.
Thank you very much. Mr. Nikolić, can you hear the proceedings in the language that you understand?
Yes, Your Honors, I can hear you and I can understand the language spoken.
Thank you very much. If there's any problems, please do not hesitate to let us know. You may sit down, please.
Thank you.
Good afternoon, ladies and gentlemen. This hearing is for the trial chamber to deliver judgment in this case. What follows is the summary of the written judgment and forms no part of it. The written judgment will be made available to the parties and to the public at the end of this hearing. We are here today to sentence Momir Nikolić for his participation in the crime of persecutions committed following the fall of the Srebrenica enclave in July 1995. Mr. Nikolić, 48 years old, Bosnian Serb, was indicted by the Office of the Prosecutor on 26 March 2002 for crimes including genocide, persecutions, and extermination. He was arrested by SFOR on the 1st April 2002 and transferred to the Tribunal, where he has remained in detention at the United Nations Detention Unit. Momir Nikolić was jointly charged with 3 other accused, and his trial was scheduled to commence on the 6th May 2003. Before the beginning of the trial, the Prosecution and Defence presented the trial chamber with a joint motion for consideration of a plea agreement between Momir Nikolić and the prosecution on the 6th May 2003. After 2 days of plea hearings and the amendment to the plea agreement, the trial chamber accepted Momir Nikolić's plea of guilt to 1 count of crimes against humanity, namely persecution, punishable under Article 5H and Article 7.1 of the Statute, and entered a conviction thereupon. Pursuant to the plea agreement, the prosecution moved to dismiss the remaining counts, and they were subsequently dismissed. Additionally, under the plea agreement, Momir Nikolić agreed to testify in other proceedings before the tribunal, including those trials related to Srebrenica. In September 2003, Mr. Nikolić testified in the trial of his two former co-accused for 8 days. A sentencing hearing was held between 27 to 29 October 2003, at which 7 live witnesses were heard, and the testimony of 4 witnesses were accepted pursuant to Rule 92 bis. As the guilty plea was made pursuant to a plea agreement, the trial chamber has considered the use of plea agreements in cases of serious violation of international humanitarian law. The trial chamber finds that, on balance, guilty pleas pursuant to plea agreements may further the work, the mandate of the tribunal. The trial chamber further finds, however, that based on the duties incumbent on the prosecutor and the trial chambers pursuant to the statute of the tribunal, the decision of whether to enter into or accept plea agreements should be taken with caution. A written factual basis for the crime and for Mr. Nikolić's participation in it was filed with the plea agreement. The factual basis and the indictment, which Mr. Nikolić acknowledged to be true, forms the actual basis upon which the trial chamber will determine sentence. The facts described therein are as follows. The crime of persecutions, as charged in count 5 of the indictment, was carried out by the following means: the murder of thousands of Bosnian Muslim civilians, including men, women, children, and elderly persons. The cruel and inhumane treatment of Bosnian Muslim civilians, including severe beating at Potchari and in detention facilities in Bratunac and Zvanik. The terrorizing Bosnian Muslim civilians in Srebrenica and Potchari. The destruction of personal properties and effects belonging to Bosnian Muslims, and the forceful transfer of Muslims from Srebrenica enclave. The criminal acts were carried out on the civilian population who fled Srebrenica enclave during the attack and the takeover by the Serbs. In Potchari, women, children, and the elderly were separated from the able-bodied men. While the men were detained, their wives and children were placed on buses and forcibly transferred to Muslim-held territory. This forcible transfer was accompanied by acts of terror, humiliation, and utter cruelty. The detained men were moved out of Potchari for execution. Similarly, the men who had escaped from Srebrenica in the column were captured and detained pending execution. Along the road between Bratunac and Zvanik, the names previously used to mark settlements and the communities or places of learning, cultural, work, or geographic features are now used to identify the killing fields. In Jada River, Saska Valley, Kravica Warehouse, Petkovic School, Pilic Cultural Center, and the village of Tiza and Okrohavo. At one occasion, Brajeva military farm, approximately 1,200 Bosnian Muslims men who had been captured from the column were executed by automatic weapon fire. In total, over 7,000 men were murdered. The trial chamber has considered the principle and the purpose of punishment in light of the mandate of the tribunal. It finds the principle of sentencing derived from national systems, namely deterrence, retribution, and rehabilitation, are applicable on international level. The application and the purpose of each may, however, be different when applied on international level. Turning to sentencing factors, the trial chamber first considered the gravity of the offense, bearing in mind that this required taking account of particular circumstances of the case, as well as the form and the degree of participation of Mr. Nikolić in the crimes. The trial chamber observes that the crime of persecutions is inherently serious. Its unique character is derived from the requirement of a specific discriminatory intent, on account of which the crime is regarded as a particularly serious offense. In this case, the gravity of the offense is demonstrated by the prosecutory acts by which Mr. Nikolić has been convicted. The crimes committed following the fall of Srebrenica are unfortunately well known. The mass murder or forcible transfer of Muslim population from this part of eastern Bosnia in slightly over 1 week was committed with a level of the brutality and depravity not seen previously in the conflict in the former Yugoslavia, which had already cost too many lives. Momir Nikolić was not unaware of the crime unfolding following the fall of Srebrenica. Rather, he appeared to be right at the center of criminal activity as the operation spread from Potchari to Bratunac and on to Zvanik. Momir Nikolić was present at Hotel Fontana during the 3 meetings, in which the fate of the Muslim population was discussed and decided. He did not raise any objections to what he was told was the plan: to deport Muslim women and children to Muslim-held territory, and to separate, detain, and ultimately kill the Muslim man. Rather than resist, Momir Nikolić recommended possible detention and execution sites. On 12 July 1995, Momir Nikolić was in Potchari. He saw with his own eyes the separation of men from their families. He heard the cries of children as they saw their fathers taken away. He saw the fear in the eyes of women pushed onto buses, as they knew that the fate of their fathers, husbands, and sons was beyond their control. He has described himself as the coordinator of various units operating in Potchari. But he did nothing to stop beating, the humiliation, the separations, or the killings. Mr. Nikolić returned to Potchari on 13th July 1995. And by his own account, he established that all was going well. The deportations continued, as did the separations. He busied himself with security arrangements for General Mladić, and when they met, reported that there were no problems. On the same day, Momir Nikolić saw columns of prisoners being marched to various sites to await their deaths. Later that night, Momir Nikolić was present when 3 other persons involved in the crimes openly discussed the killing operation. The intricate detail of the operation were discussed in order to facilitate the execution of the plan. Momir Nikolić was an integral part of the implementation of the plan in order that the aim of the operation were achieved. Further, in the months subsequent to the execution, Momir Nikolić coordinated the exhumation and the reburial of Muslim bodies. This going support proved valuable in that crucial evidence was destroyed and has prevented many families knowing the whereabouts of their missing family members. The trial chamber finds that a sentence in the range of 20 years to life imprisonment to be appropriate, based solely on the gravity of the crime for which Momir Nikolić is convicted, his role and his participation in the commission of that crime, and having taken into consideration the sentencing practices in the former Yugoslavia, as well as the sentencing practices of this tribunal. The trial chamber will now consider whether any aggravating or mitigating circumstances exist in this case, and if so, the effect of any such circumstances on the determination of an appropriate sentence for Momir Nikolić. The prosecution submits that 3 aggravating factors in this case should be considered by the trial chamber. First, the position of authority of Momir Nikolić. Secondly, the role of Momir Nikolić. And thirdly, the vulnerability of the victims and the depravity of the crimes. The Nikolić defense submits that there were no aggravating circumstances, as the aggravating factors submitted by the prosecution are subsumed in the overall gravity of the offense. The trial chamber finds that Momir Nikolić was in a position of authority as Chief of Security and Intelligence. While his tasks largely required implementing rather than giving orders, Momir Nikolić directed the military police of Brutna's brigade, as well as coordinated other units. And this was of significance to the implementation and the completion of the underlying criminal acts committed following the attack on Srebrenica. The role that Nikolić played and the functions that he performed while not in the capacity of a commander, were of significant importance to the overall murder operation that was going on. The trial chamber finds that the depravity of the crimes is subsumed in the overall gravity of the offense. The trial chambers take particular note of the vulnerability of the victims, who included women, children, and elderly, as well as captured men. They were all in a position of helplessness and were subject to cruel treatment at the hands of their captors. In this situation, the trial chamber finds this to be an aggravating factor in the commission of the criminal acts. The prosecution submits that mitigating circumstances that trial chamber should consider are the guilty plea, acceptance of responsibility, remorse, cooperation with the office of prosecutor, and the prior good character. In addition to these factors, the Nikolić defense further submits that the issue of voluntary surrender, compartment in UNDU, and the personal circumstances are mitigating factors which entitle Momir Nikolić to a significant reduction in sentence. Taking into consideration of these considerations, the trial chamber finds that Momir Nikolić's guilty plea is an important mitigating factor due to its contribution to establishing the truth, promoting reconciliation, and because of Momir Nikolić's acceptance of his individual criminal responsibility for his role in the crime of persecution. The trial chamber also considers Momir Nikolić's guilty plea as a mitigating factor because it spares witnesses being required to come and testify about painful and traumatic events. This is particularly appreciated in the case of Srebrenica, where there are numerous indictments brought by the prosecution, and further trials will likely require the presence of those witnesses. Finally, the trial chamber takes note of the fact that other accused have been given credit for pleading guilty before the start of trial, or at an early stage of the trial because of saving of tribunal's resources. The trial chamber appreciates this saving of tribunal's resources. The trial chamber finds, however, that in cases of this magnitude, where the tribunal has been entrusted by the Security Council and by extension the international community to bring justice to former Yugoslavia through criminal proceedings that are fair, in accordance with the international human rights standards, and accord due regard for the rights of the accused and the interests of victims, the saving of resources cannot be given undue consideration or importance. In considering cooperation with the prosecution, the trial chamber notes that Mr. Nikolić has met with the prosecution, testified in cases as the prosecution's witness, and has provided prosecution with information previously unknown to it. The trial chamber observes that the prosecution considers that Mr. Nikolić has cooperated fully. The trial chamber has also considered the truthfulness of Mr. Nikolić's testimony in the Blagojević's trial in assessing cooperation with the prosecution. The trial chamber takes into consideration numerous instances where the testimony of Momir Nikolić is invasive, and finds this to be an indication that his willingness to cooperate does not translate into being fully forthcoming in relation to all the events, given his position and knowledge. The trial chamber has carefully considered Momir Nikolić's expression of remorse and his apology to the victims, their families, and the Bosnian people for his participation in the crime of persecutions. The trial chamber recalls Momir Nikolić's explanation of his reason for pleading guilty, as well as his related reason for providing the prosecution with false information during the plea negotiations. Recalling that standards of mitigating factor is on the balance of probabilities, the trial chamber finds Momir Nikolić's expression of remorse is a mitigating factor, but cannot afford substantial weight to this factor. Additionally, the trial chamber has established the following mitigating circumstances. Momir Nikolić did not discriminate prior to the war and was a respected member of his community. Momir Nikolić has behaved properly while in the detention, and Momir Nikolić's family circumstances. Momir Nikolić has accepted his responsibility for the criminal acts he committed in furtherance of the commission of these crimes. He has offered his cooperation to the prosecution. He has expressed his remorse to the victims. Momir Nikolić's guilty plea will likely have some positive impact on all the communities in the former Yugoslavia and may have opened avenues for reconciliation. The trial chamber has taken those factors into consideration in determining the appropriate sentence for him. As already discussed, Momir Nikolić was an active participant in the crimes committed in Potchari, Bruchnas, and Zvanik. He did not try to avoid his official duties during those fateful days or remain on the sidelines. By his own account, he appears to have taken a very active, even proactive role in ensuring that the operation went forward and was, in his words, successful. The trial chamber has taken into consideration the crime committed in July through November of 1995, for which Momir Nikolić has been convicted, as reflected in the charge of prosecutions, and the degree and form of Momir Nikolić's participation in the commission of those crimes. The trial chamber has accorded appropriate weight to each aggravating and mitigating factor. As the trial chamber has continuously stressed to both parties and to Mr. Nikolić, the trial chamber is not bound by their recommendations relating to the sentence. The trial chamber has carefully considered the submissions and recommended the sentence by each party, and finds, however, it cannot accept the sentences recommended by either the defense or the prosecution. Neither sentence adequately reflects the totality of the criminal conduct for which Momir Nikolić has been convicted. Well, Mr. Nikolić, would you please stand up? Having given due weight to factors set out, the trial chamber hereby sentences you to a period of 27 years imprisonment. You are entitled to 610 days credit for the time you have served in the detention as of the date of this sentencing judgment, together with such additional time as you may serve pending the determination of any appeal of this sentencing judgment. You may sit down, please. Having said that, the hearing is adjourned.
All rise, veuillez vous lever.